Good afternoon, everyone.
Good afternoon.
Good
Ah,
afternoon.
ah,
Good afternoon.
okay. All right. You got an email with some attachments, correct?
Yes, we did. Yes, I did.
Yes. Okay. So before we begin unit 3, which is on mortgages, remember we had agreed we're going to go over 2 cases, the 2 that were left over. So you have Strawn versus Strawn. You have that one. And Rodan, Simon Rodan. Anyone had a chance to look at any of them?
I didn't.
Okay, which one you looked at?
I look at none. Yeah, I had a rough couple of days at work.
Okay,
Yeah, when I got off, it was like after hours.
okay, so all right. Let's look at Strawn and Strawn. So with this one here was a quieting of the Titles Act. And the main focus was to determine whether the certificate had been obtained by deceiving the court and whether it should be set aside. So it says here that the abstract of title and the several affidavits which the appellants filed in support of their petition, and the appellants are Milton and Daniel, contain false representations of fact about their being in undisturbed and exclusive possession of the whole of lot number 3. So in this case, when you read it, you find that Milton and Daniel actually had allowed the daughter, I think it was their daughter, to build a school on the property. And so when they would have put in their application, they said that they had exclusive possession, which was false. And so the Chief Justice said that what they presented to the court was they tried to deceive the court in order to obtain their certificate of title. And so now they're before the court to have it set aside on the grounds of deceit and fraudulent concealment. Let me go to the section, to the paragraph. Paragraph 13. It says at paragraph 4, the Chief Justice specifically referred to the affidavit of the first appellant, Milton Strawn, which had been filed in support of his application to claim possessory title. He highlighted that the appellants claimed to have farmed the land over a period of 20 years and to have built 2 rental houses and a preschool on the land, and emphasized the presence in the affidavit of the statutory assurance to the court in accordance with Section 5 of the Act. Then he said, going on further, he said, refer to another case. He said, the learned Chief Justice correctly, in my view, reminded himself that in considering the respondent's allegations of fraud, he was not being called upon to decide which of the parties had a better title to the property in dispute, but was simply required to decide whether the certificate of title, which had been granted to the appellants in the quieting proceedings, had been obtained by deceiving the court and ought to be set aside. So if you go further, he says at paragraph 17, he said the Chief Justice further observed that in the quieting proceedings, the appellants had never disclosed or suggested that the preschool had been built by the respondent and his wife, and it had been they and not the appellants who had been in occupation of the school. Because remember now, when you're doing adverse possession, you actually have to be in possession, exclusive possession.
Okay.
So the appellants had represented to the court in the affidavit filed in the quieting proceedings that they had built the preschool on the land, and had further represented that they enjoyed undisturbed occupation and possession of the property even to the present date, and that was not true. The Chief Justice then highlighted aspects of the evidence given on the respondent's behalf by Rosanelle Thompson Smith, who testified as to the fact of her occupation of the preschool over a 6-year period beginning in 2008, initially as the respondent's employee, and from 2010 as his lessee. Mrs. Smith also testified that the first time she had received notice of the quieting proceedings regarding the property had been in 2013. And further, that no notice had ever been posted on the property or served on the preschool or on her. And so the court said they were trying to deceive the court to believe that there was no one on the property who was claiming an interest contrary to theirs. And of course, he said that the appellants were in a dispute with the respondents, and they didn't disclose that either to the courts. And so at the end, the court decided that what transpired in 2010 before the learned Chief Justice exemplifies the kinds of egregious abuses ranging from the fraudulent concealment of material facts and the deliberate manipulation of the statutory requirements of the Quieting Titles Act. If you remember from last task, when we were having the discussion on the Quieting Titles Act, we said that it is open to abuse. And so this is another case I wanted to show you where quieting title, certificate of title was received, but after it was issued by the court, the family member came back to say, no, they deceived the court because the appellants were not in exclusive possession of that property. A preschool was built on it, and then the preschool was leased, and they did not give them notice that they were quieting this title or that they actually were on that land at that time. And what the judge did was he also said that this deliberate manipulation of the quieting title was also brought out or also warned in the Privy Council case of Anthony and Bristol versus Marion Lightburn. And that's that very, very long case that I sent to you all. Any questions on that one? That's the quieting title. The other case that I sent you, which I know you didn't read because you've already admitted it, was the the petition of Simon Rodan. Tony, you're saying something?
I need to use the restroom. I'll be right back.
Oh, okay. Anyone read Simon Rodan's petition? Okay, let me wait for her to come back. I want you to have a look at page 2 to 3, which is the abstract of title presented by Simon Rodan. And then I want you to look at page 7 and look at the abstract of title that was submitted by the Archers. So there's 2 abstract of title there. While we wait for Tony, and then let me know if you see, if anything jumps out at you. On the abstract of title. Because you have three parties competing for the same land. I'll give you a couple of minutes to have a look at it. Oh, she's back. All right. Who wants to tell me if they see anything at all in the first abstract? Very first one. No one have any questions on the first abstract of title? Remember, the abstracts of title supposed to show you the history of the property passing from purchaser, from seller to purchaser. Nothing at all? Okay, so let's start. If we look at the abstract of title by Simon Rodin, he says that the crown land was granted to Alexander Harold in 1789. Then he says there was a conveyance to James Webster. And that conveyance was to satisfy a judgment of James Hardy. Now, how James Hardy got connected to Alexander Harold, it doesn't say. But we know that that road, the main road from where this land is situated now, was formerly called Harold Road. Then it says it went from James Webster to Anthony Wallace. And then from Anthony Wallace, it went to Timothy Cox. And then it said there was commutation by the crown to David Garner. So between from Anthony Wallace to Timothy Cox, there's the name of David Garner in 1847. Then they say he died intestate. Then his son made a will, leaving no residuary estate and no device of property. Then he died. So he made this will on the 16th of August and he died in September, the same year. Then you have Maud Dew. Is she related to Mr. Cox? Don't know. And that Dew person conveyed it to Agnes Rodin, who is Simon Rodin's mother. Then she petitioned a court for certificate of title for the rest of the land acquired by Maud Dew. And the Supreme Court gave her a title to 11 acres of the property, which she sought to be quieted, because she actually asked for 19.3 acres. So Simon then says that he is on the 7.712 and the 8.2 acres of land. The 1.7 remaining acreage, he said that was conveyed by William to him. And then he settled with 1, 2, 3, 4, 5 affidavit to prove that he is actually in occupation of all of these tracts of land, 15 acres, 16 acres, and the 1.7 that he purchased independently in 2003. Now, on the other hand, one of the parties also contesting this say that they have abstract of title. And they're saying the crown land was given to Alexander Harold. And then they have the same where Webster, to satisfy the judgment debt of James McHardy, the conveyance from Webster to Anthony Wallace. Then they moved from 1808 and they jump all the way to 1960. Morrison, Louis Edward Livingston Morrison, swearing that the Wallace's estate devolved to Minvilla Archer Nee Sawyer. Then they say on the same time, Elsie Franks, 11 years later, found at the Court of Appeal to be the child and heiress of the late William Wallace Jr. And they confirmed certificate of title equity action 1 of 1965. Yes, we are on page 7 of the petition of Simon Rodin, Quieting Title Act.
Okay,
Okay. So the first one I read to you was the abstract of title that was submitted by Simon Rodin. This second one is the abstract of title submitted by the Archers. So it says here, going down to 1971, that Elsie Franks was found to be the child and the heiress of the late William Wallace Jr. So if you look at 1960, it says that Louis Edward Livingston Morrison swears that Wallace's estate devolved to Minville Archer Nee Sawyer. Then there's a conveyance between David C. Bethel and George and Spurgeon Archer. So everyone is claiming, based on the abstract of title, that they own this property, that Simon Rodin now is saying that he owns. So when you go and you read through the submissions by each party and the evidence that was given, the judge says that based upon the Archer's submission and the evidence that was given, where they said that they occupied about 2 to 3 of all of that acreage, doing some farming when he was a little boy, and that there was some mining done in the same area. The court came to the conclusion that they were going to make 3 grants based on the property. They say out of the 7.7 acres of tract land that Simon Rodin says that he owns, after his 4 affidavits, the court said that they will give him a certificate of title for 0.627 of that acreage. And the Archers will receive a certificate of title for 2 acres of the 7.712. And that's the 2 acres that they were able to state in court that they actually occupied as their homestead when the father was alive. The gentleman named Edwards received the balance of the 7.712 acre tract. And the Archers and the Edwards, they agree to a common boundary to ensure that the Edwards property is contiguous to the 1.704. But listen to what the judge had to say about Simon Rodin when it came to him and the 8.229 acreage. It says, Simon Rodin, the 8.229 acre property goes southwards of Rodin's home, which sits on a hill and abuts property identified as Crown land at the south. Having seen and heard the witnesses as they gave their evidence, in addition to the affidavits lodged, I am satisfied with Rodin's occupation and possession. The evidence demonstrates open occupation of the property, which has not, in my view, been disturbed in the 20-year period up to the filing of the petition in 2003. The Archers had contested that they were unable to see the boundaries set up by Simon Rodin from the road. And the court dispelled that. Edwards did not claim a documentary or possessory title to this property. I could not accept the documentary or possessory evidence of the Archers to this property. In any event, any such title would have been long extinguished, as there was no evidence of any possession or activity by the Archers this far into the tract. And that's how Mr. Rodan was able to receive a title for the 8.229 tract of land. The 1.704 tract of land, the court said that they were not satisfied with either the evidence or the possession or the title as opposed to that of Edwards. And then the 7.712 acre, he says that Simon Rodan, following his occupation of the 8.229 tract, sought to creep westward, this paragraph 46, he sought to creep westward from his home on the hill to occupy portions of this 7.712 acre tract. The further occupation in my mind was done outside of the view of anyone other than his close circle of friends and acquaintances or workmen engaged by him. Johnson, whom I've already indicated was unimpressive as a witness, stated initially when cross-examined that the buildings could hardly be seen from the road. He later stated that they were visible on the hill from the dump road. Surveyor Donald Thompson, whose evidence I accept, stated that any structures on the property was not visible from the road. He stated that no one would have been able to see what Rodan was doing. The judge went on to say, I therefore did not accept Rodan's statement as to omissions by Thompson and find that the structures nor the parts were simply not present. Rodan undoubtedly would have ensured the plan reflected what was on the ground. And then the judge goes on that the unregulated construction, however, was indicative of the stealth, that's paragraph 49, with which Rodan engaged with his tract. He said, no building permits were obtained for the construction of multi-story buildings, and therefore no inspections by the authorities took place. In evidence, Rodan admitted that he used the 1976 occupancy permit for his existing home to misrepresent to the authorized authorities that the permit related to the new construction in order to obtain power. And that's why he lost in this matter in gaining that 7.712 acre tract. Because the court said that he dealt with it stealthily and got no permission to build on the land. So I gave you this one because it shows you an abstract of title. And remember what we said, abstract of title goes how far back? 3 ways it can go. What's the 3 ways for the abstract of title? How far do you go?
Preferably 30 years.
30 years.
Or as far back as the quieting goes, whichever one is the lesser amount.
Or crown land.
Or crown land, yeah.
Yes, or crown. But you can see in both of these abstracts, there are gaps. In both of these, there are gaps. And what was so surprising is, I guess it's difficult to know exactly which tract of land they're referring to, because you see that once at the very beginning, when the crown land was granted to Harold, you can see, you can track that. But then things start to get muddy around in the 1950s. They have two different sets of people claiming conveyance of the land. Because you have the Archers claiming in 1981 that Spurgeon and George Archer held the conveyance. Whereby you have here that Simon Rodan is saying that he has the property from 1974 from his mother, who received it from Maud Janet Dew. while the Archers is saying that the property came from Elsie Franks, who was the heir of William Wallace Jr. So now you see where in the first class I
Ms.
said,
Archer,
yes. Go ahead.
you seem
Go
to
ahead.
keep disappearing.
Who's disappearing? Who's this? Go ahead. Who's disappearing?
It's Tony.
Why you? Oh, oh yeah, she's gone again. Oh. Hmm. Oh, she's back, but not on. She's probably having internet issues, eh? But I wanted you to see why it is time consuming and why there's so much difficulty with obtaining a good certificate of title. And you could see how persons go about seeking adverse possession of property. And this one by Mr. Rodin is a good case. How he stealthily started to take possession of the land, built on the land without permits. And this is why I said in the first class, it is so important for us to start to have registered land.
So did Mr. Rodan end up with any land?
Yes, he did.
Just the 1 point some?
No. Oh, okay. So there were 3 tracts of land, remember?
Yeah.
Okay. So from the 7.714,
Mm-hmm.
they only gave him 0.627.
Okay.
And then they gave the Archers 2 acres out of that.
Mm-hmm.
And Mr. Edwards got the balance of that.
Okay.
And the judge said that Edwards didn't claim any title to that property.
Okay.
And he said the evidence that the Archers presented that they owned that property, the judge says that he could not accept that documentary evidence.
Mm-hmm.
Because remember what I was telling you, when you look at the abstract, there's too many gaps. You have 2
Yeah.
different people
Mm-hmm.
in that space of those years, 2 different people claiming ownership of the property.
Yeah.
And so based on the 2, you have to see which one has a better certificate of title.
So this would come about because maybe somebody was squatting on the land and trying to sort of sneak their way on it.
Yeah, could be, but this is we going so far back because I'm saying if you look at the abstract of title that Simon presented, right? He went 1789, the crown land was granted. Then he went to conveyance in 1807, 1808. Then he went 1809. And then he went 1847, 1867, 1886. And after that, from 1886, he jumped to 1954 when his mother purchased it. And then BEC acquired a part of the land. And then his mother petitioned the court for certificate of title to get the remaining of the acreage from the same person called Maud Dew. And the Supreme Court granted a title to her for 11 acres. She quieted that in 1966. But okay, so go to the Archers now. The Archers is saying after the 1808, they say in 1960, they have an affidavit where Lewis Morrison swore to being acquainted with William Wallace and Anthony Wallace and Philip Wallace. And Morrison swears that Wallace's estate devolved to Minvilla Archer Nee Sawyer. So in 1960, you have an affidavit. But if you look at what Simon presented, what does he have? He has a certificate of title, where his mother quieted the property. So in 1960, they have two affidavits, which can't stand up to certificate of title. Then it says in 1971, now this is after she would have acquired property. It says in 1971, Elsie Franks, found by the Court of Appeal to be the child and heiress at law of the late William Wallace Jr., and confirming a certificate of title and equity action 131 of 1965. I think when you read the case, you'll find out this is it was a different piece of property. It wasn't the same one that's in question now. So, like I said earlier, the Privy Council has also made that comment that this quieting of Title Act, it lends to being abused. So in the first case we looked at with the Milton Strawn, you see where Harcourt Strawn did not tell the court that the matter was, the property was under dispute. And then he lied to the court saying that he had exclusive possession when he didn't. He had a school built on it by a family member, which had also been leased. And I just wanted you to notice also that these properties are not properties where the titles would have just been conveyed. If you look at these go way back. Any other questions? Tony, I know you missed some. No questions on adverse possession. That means no. So let's go to chapter 3. Chapter 3 speaks about different types of mortgages. Now, I know everybody says this, I am going to the bank to get a mortgage. That is not the correct way, or the whole idea is not what a mortgage is. You actually go to the bank who gives you a mortgage. So what you actually is getting is money. And that money is a mortgage loan. The mortgage itself is the security. And that security is what the bank holds until you repay that loan. So whenever you speak about mortgage, you have to put in your mind, you're talking about a security. And a security has different functions. So one, it gives you the incentive for the borrower to repay. So that means that when you actually sign that mortgage document, you are saying to the lender, I am going to repay this loan. The borrower has to repay it if he is to redeem the security. Because you know what happens when you don't redeem the security. And that's next class. If the borrower fails to repay, the lender has something to sell. So you never want to get to that stage. So the first thing you have to think about for a mortgage is how do you define it? What is it? And it's simply a conveyance of land for the payment of debt, for the discharge of some or other obligation for which it is given. That's simply what it is. But in more legal terms, a mortgage is an interest in property. Because remember, in the earlier classes, we said that when you have land, you have both a legal and an equitable interest in that piece of property. You don't own the land. You have an interest. So when you mortgage your property, the bank then takes that legal interest and you have that equitable interest. So that interest in that property creates a security for the loan or the payment of the debt. And that arrangement is terminated on the repayment of the loan or the debt. So what the borrower is doing when he enters into a mortgage is he actually gives the borrower ownership of that property as security. But he retains the possession. And remember, ownership is transferred subject to reconveyance or redemption. So yes, you have actually given ownership of that property to the borrower, but that will be transferred to you for reconveyance or on redemption. That means when you paid the loan off in full. The terminology used is the borrower who actually grants the mortgage and gives the borrower the money is called the mortgagor, and the lender, no, the borrower who offers and grants the mortgage over the property is the mortgagor. The institution that actually lends the money is called the mortgagee. And so those are the two terminologies you'll see in the mortgage deed. So there are three types of security over land or real property: a legal mortgage, an equitable mortgage, and an equitable charge. The legal mortgage, that is where the legal interest on the mortgagee and is only granted by the mortgagor who has a legal estate in the land. And remember, legal estate is either the fee simple or lease. And the legal mortgage gives the lender more security. An equitable mortgage is someone who has a life interest in a property. And this confers an equitable interest on the mortgagee. And it may also be granted the mortgagor who has a legal estate. But if you only have an equitable interest, like a beneficiary of a trust, we spoke about in the last class, he can only grant an equitable mortgage of his interest in that property. Any questions on that? Recall what I said when you have a trust. When you have a trust, the beneficiaries of an equitable interest in the property. And so if there is a loan to be granted, the only thing that they can actually give the bank is their equitable interest. And so what they will do is they will actually grant an equitable mortgage on that property. In another way, you could have someone who have a life interest. So say if someone in a will leaves a property to his daughter, and he says that she is to remain in this house for her life, and upon her death, it is to go to her children or her brother, she has a life interest. And that life interest, she can actually mortgage that life interest as an equitable mortgage. The other one is an equitable charge. And an equitable charge So an equitable charge confers an equitable interest on the chargee, but with more limited rights than the equitable mortgage. So a legal mortgage may be either one of the following: is a lease, where the mortgagor grants to the mortgagee a lease of the land, or it can be a legal charge, where the mortgagor charges his land to the mortgagee by deed. A legal mortgage by charge is the same as a mortgage over land, and it gives the mortgagee all the rights and the powers in law, including but not limited to the power of sale, in the event there is a default. The mortgagor effectually grants a charge to the mortgagee over his land by way of a legal mortgage, which is typically granted by deed. An equitable mortgage is an alternative to a legal mortgage, and it can be created either by agreement or by deposit of title deeds. By agreement, the borrower may agree with the mortgagee to execute a legal mortgage if required to do so, in consideration of obtaining a loan. By deposit of the title deeds to the lender is merely for safekeeping, then the deposit does not create a legal mortgage, as in the case of deposit made to the lender as security for mortgage. So the mortgagor and the mortgagee, for the purposes of an equitable mortgage, normally execute a document known as a memorandum of deposit, which the mortgagor signs to evidence his intention to create an equitable mortgage only, and the terms of the arrangement with the mortgagee. The memorandum of deposit or the equitable mortgage can contain an undertaking to create a legal mortgage if necessary or if it is required. If the memorandum of deposit is in the form of a deed, it may include an irrevocable power of attorney, which may give the lender the power to sell or appoint a receiver in the event if there is a default. An equitable mortgage is only actionable if it is in writing and signed by both the borrower and the lender. The next one is the equitable charge. Here, the mortgagor, in consideration of the financing by the lender, agrees in writing to allow specified property to act as security for the loan. And the bank must apply to the court, in this instance, for an order to sell the property in the event of a default. A mortgagor can also create a second or subsequent mortgage of property, which will write after the interest of the first mortgagee, if it has taken the relevant steps to protect their interest and security by stamping and recording the mortgage document. If you're going to create a second mortgage, the mortgagor has to have equity of redemption. And they use it as security for borrowing. Yes, Tony?
So in actuality, you could have two mortgages on one home?
It used to be done in the past. Banks don't favor that now, but yes, you can. They don't do it because the same caution I have here in the next paragraph. Because you have to look at, let's say you got one mortgage and you got that, let's say the value of the house is 250. You got a mortgage for, what's the maximum you can get?
For your mortgage?
One, yeah, let's say the value is 250. 150?
The other one,
If the value is 250, the maximum you can get would be the 250.
sometimes 200.
You get the full thing? No, you can't get the full thing.
Well, I mean, minus minus whatever down payment and deposit, but the thing is, I think what you're asking, where you're going with it is that if you do get a second mortgage, it can exceed the value of the house between the first mortgage and the second mortgage.
That's correct.
They're gonna make.
It cannot exceed it. But remember now, you also have to look at the value of the house itself over time.
Yep.
Because if that borrower is not keeping up with upgrades, following the covenants that are in the mortgage deed, doing repairs as necessary, you could find yourself in the state when it's time to sell, that the first borrower actually takes all of the money.
And that's the
That
thing,
can't-
they seldom do that.
And exactly, but that is one of the covenants. And I think one of the reasons you see that happening a lot is that the bank itself doesn't actually go and check these homes. Because I've seen a home that the bank just repossessed, going out of, where's that now? Seabreeze. That house has actually sunk into the ground. Now, I don't know whether that area was filled in before, but you could actually see where the house is sunk into the ground. That house is not being painted, I would say roughly about 10 years. All of the pillars for the wall on the ground and on the second floor are all decayed. The roof is rotten. The people just moved out of the house now, but the house is in total decay. How can the bank now get its monies back? First, I don't see who's going to purchase it unless they want just the land, because it's a 2-story house. And I'm not aware of banks actually going to visit these homes after they have granted the mortgage.
No, they don't.
And even with what we went through a couple of years ago, with all of those homes having to be sold after they were repossessed or put in a block and sold, I still don't see banks taking the precaution that they need to take in granting these mortgages. And that's a risk that a bank takes when it grants mortgages. Everybody can compete with interest rates, but you have to look at, after you put these loans on the books, how do you ensure that you're going to get your money? That's the question that you need to ask yourself.
And that's
How are you
why,
going to get your money?
that's why in the case of an existing home that somebody is purchasing, the term should be set based on the age of the house and the deterioration that's factored in, rather than the age of the person.
Exactly. And that's something that I think bankers need to put forward. Because in the long run, it just, it's bad on both sides, to the borrower and to the lender. I have a case I want to discuss with you. Remember, I told you tonight is a short case. I mean, a short chapter, because next week is longer. This one is Mitchell, Philip Mitchell, and Brenda Mitchell. I didn't send it to you, correct?
I got it.
You have that? Brenda
Yes.
and Philip? Okay.
Uh-huh.
No, because some of them bounced back.
Oh,
I just wanted to make sure you got it.
Yeah,
Okay.
you did bounce back from me, but I was able to recapture it.
Ah, okay. Okay. So in this case, this husband and wife, they decided to represent themselves. And they obtained a mortgage with various further charges from Finco for property in Twynham Heights. So in 2009, the Mitchells were notified of a breach of the conditions of the mortgage and further charges by failing to make the loan repayments. And they were advised that if they did not pay the outstanding amount of $319,000, legal proceedings would be commenced against them. So the loans were not brought current, and they refused to vacate the home to allow Finco to exercise its power of sale. So I'll tell you right now what they purported. This husband and wife. They were told in 2014, paragraph 4, that they had to pay the amount outstanding under the mortgages and the charges. And the judge said that if they failed to pay the outstanding amounts, they should give vacant possession of the mortgage property to the bank within 60 days. So now they're appealing this decision. And they're appealing it on 39 grounds. And they've set them out below. And the ones that I want you to point out is where they said right here. Oh, I didn't tick it. Oh, here. He says in paragraph 5, the learned judge erred in fact in that he failed to observe undisputed prima facie evidence of real property and insurance fraud, forgery, fraudulent misrepresentation, false attestation, breaches of contracts, breaches of statutory duties, economic duress, undue influence, coercion, inter alia, perpetrated against the appellants by the respondent pursuant to the subject matter before the court, and should have granted the appellants the strike good relief they sought pursuing to the clean hands doctrine. What do you think they say in there, the Mitchells?
They're trying to say that the court is in cahoots with the bank to sell their house up front.
Ah,
and then
yes,
probably
yes.
give it to one of their friends.
Yes, yes. That is what they're saying. How you know so well?
Just a lucky guess.
Yes. So they've gone through 39 of these things. Saying here, the learned judge erred in ignoring and failing to consider material probabilities of the second appellant's signature being forged by Finco's manager, who was also the applicant's loan officer. So and then they actually said that their signatures were forged on the documents. The learned judge erred in holding that Finco should have provided the court with evidence from an independent handwriting expert to prove, no, not Finco, that Mrs. Mitchell, she claimed that her signature was forged. And then he said that the judge was wrong also in holding that Finco is entitled to exercise his right under the mortgage. So what he was saying is this: He said when they went to sign the mortgage document, they got this paper, but the paper was not the full mortgage. And so as far as they were concerned, they didn't sign any mortgage documents. He said it was fraud and forgery because he didn't sign the true copies of the mortgage. He said the ruling of the judge was unsafe, unsound, and set a dangerous precedent. He said the judge had secret communications with Finco. And he said the judge also held private hearings relative to his recusal with Finco. And that the judge failed to consider material facts and evidence. So let me see if I can tell you what the judge said. Because they said that the judge had a lot of bias. So the judge said, a fair-minded and informed observer, knowing all the facts that are capable of being known by the public, would, in my view, not conclude that there was a real possibility of bias on the part of Judge Evans. That's paragraph 18. He said, I entirely agree with Judge Evans in the court below that is not sufficient for a party to simply deny the validity of the mortgages and thus create a bar to the grant of the order sought. The court must be satisfied that there is some evidence which give rise to a serious issue in that the evidence is sufficiently cogent to warrant trial. And he said that the documents produced to the court reveal their signatures duly attested by witness and notarized. In addition, the evidence indicates that the independent advice was obtained from the law firm of Gibson and Rigby before the documents were signed. In those cases where the defendants assert that the second defendant did not sign the document, no independent evidence such as handwriting expert has been produced, nor has the second defendant herself sworn an affidavit to make this assertion. So then the courts went to talk about what is delivery. And saying that a deed is different from a contract. A deed changed as long as it has been signed, sealed, and delivered. And delivery in this connection does not mean handed over to the other side. It means delivered in the old legal sense, namely an act done so as to evince an intention to be bound. Because that is what the Mitchells were saying. The Mitchells were saying that they didn't have the full document and it wasn't delivered to them. And the judge is saying that delivery doesn't mean the same thing as in a contract because it's an act done. So at the end, the judge said, quoting section 22 of the Law of Conveyancing Act, it said a mortgagee shall not exercise the power of sale conferred by this act unless and until the mortgagor and default has been made in payment of the mortgage money or a part thereof for 3 months after such service, or some interest under the mortgage is in arrears and unpaid for 2 months after becoming due, or there has been a breach of some provision in the mortgage deed. So he said the arguments by the Mitchells is unsustainable as the interest under the mortgage was in arrears and unpaid for periods in excess of 2 months after becoming due. This would give the mortgagee the power under section 22(2) of the Conveyance Law and Property Act to exercise the power of sale under the mortgage. And for these reasons, he said the appeal is unmeritorious and it is dismissed. And so that meant that the Mitchells lost their case. And they either had to pay the outstanding amount of $319,000 or let FinCo exercise its power of sale. Any comments?
That money they took to be appealing, they may as well try put towards their mortgage.
I don't know
Yes,
why
they
the-
should have, but they didn't.
I don't know why the Mitchells thought that they could go against the judge, especially if they thought that he was in cahoots with the bank.
Oh, Lord. These people are just funny, really funny.
But I do agree with the Mitchells. I do believe that
What?
these judges, yes, these judges and these especially like I don't know what you call them, like the people, the persons running the bank, they be in cahoots with each other. Like they know each other, they eat and drink with each other, like they all be tied in one circle. So I believe it's some truth to the Mitchells, whatever they were saying, but at the end, you don't win against the bank
You
or
sure?
going against the judge. Yes. Okay, let me give you an example, right? When
Go ahead.
when I was purchasing my property and on the plot plan, it was a certain square footage that we were supposed to get, right? At least we thought that we were getting. And the surveyor, we took the surveyor, we took the vendor to court, and the vendor's attorney, the judge, and the surveyor were all friends. And
But of
nothing.
course, they're all working in the same, I mean, in the same
Right.
field.
Exactly. No, but they were friends. And it's like, it was a clear cut case. And they were like, the judge was like, well, that didn't hinder your decision before y'all purchased the property. And we just found out later that they were all friends. And it's just a whole mess behind the scenes. So I would not go against the bank. What the Mitchells should have done is, especially if they were getting, doing it through salary deduction, it's just easy to quit your job and find another job so you don't have to pay salary deduction.
What?
Yes, until they sell your house, because you could never win against the system.
What kind of advice you giving?
I ain't giving no
No.
advice. I'm just saying.
No.
But I know
Oh,
persons
okay.
that do
All right.
it.
Okay. Okay, hold on then. Let me get your comments on this one. I don't think I sent you this one. Did I send you the Maycox?
I don't have that one.
Okay, well, I'll send you it as soon as we finish in a little bit. This is BOB versus the Maycox, husband and wife, Herman and Sabrina. You don't know them, right?
No.
Okay, so on 17th of December 2010, they entered into indenture of mortgage, which was granted by Bank of the Bahamas for property, mortgage premises, and of course, that premises was used as security for the loan. The loan went in default. You hear when I said they signed it, right?
Yeah.
December 2010. The loan eventually went into default. And by an originating summons filed on the 3rd of April 2012, action was commenced by the plaintiff, BOB, against the Maycox for the following relief. They wanted payment of the sum of $268,184.31 as to the principal outstanding and $4,132.74 for interest outstanding up to the 29th of February. And they also asked for possession of the home. So on the 8th of August, the judgment was granted by the court in favor of BOB against the husband in terms of the following: that Herman, the husband, paid the BOB 268,184.31, and also the interest of 4,132.74. And then they asked Herman to deliver the said property and pay all the legal costs. Now, the Maycocks say, husband and wife, they attended the hearing of the originating summons, and no, neither of them attended it. They were not present when the judgment had been granted. But the court received an affidavit from Constable 3390 saying that he had served them with a notice of appointment to hear the summons on the 19th of July, 2012 at 7:45. He said he had delivered that. On various dates during the period from 2016 to 2020, a writ of possession to enforce the judgment was issued by BOB against Herman. The most recent writ, which was issued on the 28th of September 2020, is the subject of the defendant's application. The defendants, the Maycocks, are saying that they entered into the mortgage to secure a loan in the amount of $273,000 to purchase a commercial fishing vessel. The mortgage was for 15 years, and the monthly payment was $2,770, of which $1,400 was to be paid by Herman, the husband, and $1,370 was to be paid by the wife via automatic deductions from her salary. The mortgage went in default due to the changes in Herman's financial circumstances. So the monthly deductions were still coming out of the wife's salary that remained in place and still in place. And she states that since the beginning of the mortgage, that money has come out, and she brought along as evidence to the court her salary pay slip. Listen good now. During the period 2012 to 2016, there were various discussions and proposals between the parties for the restructure of the debt, but a restructure did not materialize. So although this action was commenced in 2012, it was not until July 2016 that the Maycocks became aware of it, and that judgment had been granted in favor of BOB for the sum of $268,000, along with vacant possession. So when the Maycocks became aware of the judgment, they continually informed BOB that service of the proceedings had not taken place, as stated by the constable. Listen now. Discussions regarding the restructure of the debt continued in 2017. According to Herman, in his affidavit, he said that every time we made some progress in respect of the restructuring, BOB changed officers and the process started all over again. Then in early 2019, the Maycocks became aware that their home, that is, the mortgage premises, had been advertised for sale in the newspaper, and they immediately contacted BOB. Arrangements were made for a meeting to take place, at which the Maycocks were encouraged to make an offer to settle the debt. So in April 2019, the Maycocks offered to settle the debt, and they would pay BOB $250,000, and BOB accepted this offer. However, the Maycocks were not able to qualify for a loan anywhere else. So in 2020, the Maycocks' home was again advertised for sale in the newspaper. On October 1st, 2020, the Maycocks were served with the 2020 writ, after which they engaged legal counsel and filed the present application. So what do you think about that one?
I
Any
think
comments?
I thought the ending because my internet keeps going in and out.
So what happened to them in the end?
Oh, why you want to get to the end before you give me your comments? Okay, so the argument was made that the statute of limitation had run out on that judgment that BOB was holding. That was the argument. And the judge brought in some cases, not the judge, the lawyer brought in some cases, but it was refuted. Let me tell you how it turned.
Mhm.
The lawyer said that they couldn't rely on the cases, the precedent cases. And they said the Homeowners Protection Act 2017 applies to all financial institutions which provide, purchase, or service mortgages, which are defined under that act to include a charge on property primarily used as the residence of a mortgagor for securing money for the construction of a dwelling house, educational or medical expenses of the mortgagor, or commercial ventures. So the mortgage in this present case between BOB and the Maycox falls squarely within the definition, and the judgment is clearly subject to the provisions of Section 23(3) of the Homeowners Protection Act. So they argued again. And then they went to the savings clause under the Homeowners Protection Act. Because the argument is saying that the writ is not valid anymore. And then they went to argue that BOB should have obtained leave from the court if they wanted to maintain that that writ for 2020 was still valid. And then the court said in the present case, the issuance of the 2020 writ without the requisite leave is a proceedings within the scope of the rules and should be treated by this court as a mere irregularity. So they discarded that too. So the question then came was, if when the Maycox said that they would give the 250, they didn't give the 250. And so the question is whether BOB could be stopped from enforcing the judgment due to the agreement that they made for the 250. So the judge said, in this case, in 2019, the Maycox the BOB accepted the offer of the Maycox to pay $250,000 in full satisfaction of the judgment debt. And then the Maycox did not make good on their offer. I agree with the submissions made by Mr. Davis on behalf of BOB that the agreement for the Maycox to pay the lesser sum of $250,000 is not supported by consideration. So with regard to the Maycox complaint that they were not served with notice of the hearing, it is clear that when the judgment was granted, the evidence before the court showed that BOB had been duly, that Herman Maycox had been duly served. It is also clear on the Maycox's own evidence, if it was to be accepted, they became aware of the judgment in the year 2016. Yet, up to the time of their application, neither of them took any steps to appeal or otherwise impeach the judgment. Estoppel does not arise, and any event, the present application is not the proper forum for the Maycox to complain about the circumstances in which the judgment was made. So in all circumstances, I conclude that BOB's right to enforce the judgment was not statute barred at the time of the issuance of the 2020 writ, and the 2020 writ is not invalid. I also order that the validity of the 2020 writ be extended to 28th of April, 2022 to make up for the time, the filing and the defendant's application on the date of this ruling. So either they pay or the bank takes possession. But you see where the bank went wrong, right?
BOB is
Yes.
okay.
And
No, I just asked.
you
No, I
said
just
that to say
asked
what?
him.
I thought you were leading to that's why
No.
they won. But would you see what went wrong, right? After they got the judgment, this, the payment was still coming out of her salary and being applied to the loan. And they had conversations with the couple for over 4 years. But you already had a judgment from the court.
Yes,
So why when the conversation, I don't understand. If you granted the loan in 2012, December 2010, and you go to the court in 2012 in less than 2 years, but the money is coming out.
and that was my thing too. Like when I thought about it, it isn't like they were running from the bank because her
No.
salary is still coming. So right then and there, they could have resolved this by just restructuring the loan, doing it for a longer term so that her salary alone can cover it. Because they're still getting her salary. It's only her husband saying things with him.
But when you read this, I don't see where the judge took into consideration the comments that they made.
Yeah, even with the loan officers changing, and so every time it
Exactly.
was like it was starting their case all over again. It was really unfair to the clients.
Exactly.
Yeah.
They were frustrating the clients
Yeah.
for over 4 years. But you trying to tell me for this amount of money, the loan officer was not aware that this was a loan that a judgment was granted? Wouldn't that be with the loan manager?
Yeah.
A matter that's being before the court. Well, that would not be with a regular loan officer. That's why I can't fathom how that file could still be with a loan officer.
And that file is supposed to be taken out of the branch.
Exactly.
Yeah.
What usually happens in the case of a foreclosure is once the decision has been made to begin that whole process, no payments are taken anymore from the client. It's usually stopped right then and there. And once the judgment has been made, they definitely don't generally take any further monies. And maybe the file was still with the loan officer because they were attempting to work with them and restructure the loan. But why would you do that after going into foreclosure and getting a judgment? That makes no sense at all.
Exactly.
But I think but I think because it was salary deduction, I really don't think that they stopped the salary deduction. I don't think I can't think for all banks, but I don't think that they stopped salary deduction, even if it goes into foreclosure.
But what
So
happened?
Why?
that they may not be applying it. That's why I tell you with the comment, because I've known plenty persons that actually quit their jobs. So whose homes went into foreclosure, but the monies were still, the banks were still taking the money. And so they actually quit their job to find another job because, then the salary deduction stops because you don't work there anymore.
You can't be serious.
No, I'm serious. It's real life. And so therefore,
No.
even though your home is in foreclosure, you understand you're waiting for the bank to sell the house so they can pay it off and either give you monies back if they could sell it for market value after they pay out what you owe. Yes. Or else because your salary does not stop. And that's why her salary kept they kept accepting that money. Because even though they accepting that, it's still short. It still don't meet the entire requirement in the system, especially because they didn't restructure it.
You know something else that just came to my mind too? They got a mortgage. They used their home as collateral, but they got this mortgage to purchase, not lease now, purchase a commercial fishing vessel.
Right.
Why couldn't they use that as security? And make this a commercial loan? Why wasn't this a commercial loan? Why did they take their house as collateral rather than this actual fishing vessel?
Well,
Because
for
then
one,
they
the
use
house
their-
is more secure as collateral,
Right.
sorry, the house is more secure collateral. And you can sell that house, resell that house to numerous persons who are interested in buying, but a commercial fishing vessel is a very limited market.
No, what I mean, yeah, I get your point, but I mean, they as a couple, why would they put up their house instead of the vessel?
Because they didn't buy, they used the house to purchase the vessel. They didn't have the vessel yet, so they couldn't use it as collateral because they were using that monies from the when they refinanced to purchase this fishing boat. So they had to use of course, the home as collateral.
Okay, so they got the money to purchase this fishing vessel, right?
Right.
Okay, so he couldn't pay his 1,400. So where's the money that's coming from this commercial fishing vessel?
They spending it on something else. Because I know, I mean, I know fishing, they go in seasons, but those fishermen make money. So I feel like when you make a lot of money, when you're making a lot of money, some persons don't know how to properly budget that. And they, some seasons are really good and then some seasons are really slow. So, I mean, the ideal thing is to put more money on the loan for slower periods. But obviously they weren't doing, I don't know what they were doing with the money, but he wasn't paying his half. And
No,
I
he
don't
was
know
not
why
paying
she
his-
wasn't making him pay his half, but they both in the loan together because it ruins her borrowing power as well.
Yes.
Sometimes what happens is when you have one party with salary deduction and maybe the other party promised to bring the money in and pay it over the counter, you as the spouse may think that that other spouse is actually going into the bank and paying their portion over the counter, whereas they may not be doing that. And by the time you realize it and find out, oops, now we're in arrears. And, then it's a problem.
Mhm.
Not just because people are married and living in the same house, does it mean that they are honest or communicate with each other?
Yeah, but then the thing is, why did the bank entertain this conversation for 4 years?
Because they quasi government.
Their bank, it did the whole,
it's
the whole
Different. It's different. It's different, Ms. Arch. Like it's different than the commercial bank.
they are a commercial.
Yes, but what I'm saying is they still have a lot of interference. I don't know. I don't work the BOP. Maybe someone in there could say.
Isn't somebody from BOE? I think so. It's just not. It doesn't make any sense. When I read this one yesterday, I said I was going to send this one to you all. I said, no, I think I should read it first. And then I read it. I said, but it don't make any, I don't understand what BOB was doing. You got a judgment, but still your staff is having a conversation. I
And
don't understand.
maybe they held the house because it could be that the Maycocks borrowed more money than it really cost to purchase the boat, and maybe took some of the money to purchase the boat and some of the money to do something else. And that may be the reason why they didn't hold the boat as well.
Well,
Because I mean, BOP is commercial. I'm sure that they could have very well had financed the boat on its own.
yeah, that's what I
if-
was saying. I don't understand. Well,
They
they should have.
of qualified with-
Yeah.
You know what I mean?
That's
Or
probably what
commercial
happened.
Vessel. So the house probably was the best option for them.
It don't sound like nothing was the best option for them. If they gonna have a conversation for 4 years, I know they have entered a judgment. They have a judgment entered on the persons. It doesn't make any sense.
So a
I
lot of
smell a
these,
fish.
yeah, a lot of these officers are not looking out for the best interest. They trying to make their target. So that may have not been a good loan from the beginning.
That's what I'm saying.
Yeah.
But look at the
It's-
fact that they did later on offer 250,000 to pay off the mortgage, even though that was less than what they actually owed, and the bank was willing to take it. But they couldn't qualify anywhere else. So they probably ran all around the island to this bank and the next bank trying to get, qualified to get that money. And clearly they couldn't. So
What,
I
and
mean,
what I'm telling you, wouldn't that, it leading either two way? I think they were trying to get a loan based on the value of the boat.
But how could you even accept an offer like without letting them bring in their approval from the other institution to say that they were actually approved for that amount? That's, you know what I mean? That's like me saying, I come to bring 250,000. Okay, well, where you getting the money from?
They didn't
Okay,
ask
were
that
you
question.
approved?
All they says after they couldn't
Yeah,
do it, they
like-
said, oh, they couldn't qualify for a loan. How you
Like-
qualifying for another loan for 250 to pay that off and you can't pay the loan you paying? That don't make any
And
sense.
And you need a credit reference from the bank where
But
you are.
the bank where you get the loan
now.
from,
So
something is
I-
not right. Someone
know,
wanted that, someone
yeah.
wanted that commercial boat.
someone
Someone have to want that boat. Or
I
the
don't know.
house. But the whole arrangement doesn't make any sense.
I think it boils down to the fact that the Maycox, they just didn't prioritize where they should, focus their spending, and either they had no scruples or got bad advice or something. But at the end of the day, even though it could have been a marvelous opportunity to have the fishing boat and have the house, and, like Donalia said earlier, the fishermen, they normally make really good money whenever they actually do go out to sea. But he might have been a lazy fisherman. He might have
not
just
only
been one of
that,
those husbands, when you
but-
think he out to work, he actually off doing something else.
but not
Or he
only
on the
that,
boat
the
sleeping.
chef- doing a good job until the boat broke. I don't know what to say, but I
And
know
they,
what.
they do require a lot of maintenance. 'Cause
Yes,
even for
they
a certain period of time, you have to take them out of the water and clean them and
Right.
repaint them
So-
and do all kinds of stuff.
I feel that they bit off Nick and chew, but imagine just this one case. I saw Bank of the Bahamas have 1,000 more of these in the pipeline.
Yeah. But I think they really seriously when they give mortgages. They act the whole thing from the very beginning when they sat down to get this mortgage is not right. From the very beginning, it's not right. It's just not right.
So it could be possibly be, because a lot of clients, when they come to the banking organization, all they want is to get that loan.
I know.
Even though you as an officer or the manager or whatever may be telling them, this isn't a good idea because, of your debt service ratio and whatnot. You have some clients who will go to any length and extreme and go over your head to this one and that one and basically undermine you just so that they can get what they want to get. And a lot of times it's that, you see that, hey, there's reasons why there's room for skepticism. And still, like I said, they just want what they want when they want it. And they just don't look any further than their nose, really. And then usually those are the ones that end up in this kind of scenario.
It's
And then
sad.
everybody wants to blame the poor bank and say it's the bank who's being nasty and miserable and they trying to kick these people out of their homes and all this stuff. And, in many instances, it could be avoided too if they would come and have a dialogue before the bank has to go into foreclosure. Because every bank they are at liberty to go and exercise their rights for satisfaction after three consecutive months of non-payment. And very seldom do they do that immediately. They usually give them a lot of wiggle room and leeway before that actually takes place. A lot of these persons, when they're in arrears and they go into foreclosure, when you really check back into the whole nitty gritty of it all, that sometimes they've gone for years without paying.
Yeah. It's sad.
And that's unfair because there's a lot of persons out there who would really, who maybe the bank doesn't love, yet they'll make sure that they pay every scrap of their money every month, even if they have to do without other things, and make sure that their mortgages are paid.
Yep. That's a sad one. It's a sad one. All right, I sent you all an email just now. Oh, why yours keep coming back? Let me see. I have a failure. Who's that?
Yes,
Simmons?
ma'am, my internet in and out.
Oh,
So
you think that's why?
I'm just trying to catch up on what y'all was saying.
Okay, all
But
right.
it keeps going in and out, so I'm missing out on a lot.
Okay, so my next case before we close for the night is the one I just sent you, Kalina versus Marina Miller. In this one, Marina had a mortgage, and in the mortgage deed, there are covenants. And one of the covenants was that she would pay the maintenance fees. For the condominium that she was in Grand Bahama. So it says here that Kalina, she was indebted to Kalina for the sum of $91,391 under her mortgage. Now, she had a first mortgage, and this amount of $91,000 was related to condominium maintenance fees that Kalina paid on her behalf. So they advanced this amount that was secured under her mortgage. Now it says here that the mortgage had a clause says that at all times during the continuance of the security, duly and regularly to pay all taxes, rates, assessments, maintenance fees, service charges, and outgoings with respect to the mortgage property. The next clause stated that it shall be lawful for, but not obligatory on the lender to advance and pay all sums of money necessary for the purpose of keeping up an insurance on the building, which are now or may hereafter be erected on the said hereditaments, or for remedying any breach or breaches of covenant or obligation, statutory or otherwise, imposed on the borrower or implied by law or under the provisions of the mortgage. So she was in default of her maintenance fee from November 1993 to July 2011. and the bank paid $49,000 to Lakayan Towers on behalf of what's the woman name again? Marina Miller. And the funds were dispersed on her behalf by Kalina. The Kalina notified Marina by letters that if she didn't settle the outstanding fees in 14 days, they would pay the maintenance fees for the condominium, and that any funds dispersed would be added to her mortgage from the dates of the letters that they sent to her. Kalina also notified Marina by further letters that they had paid the maintenance fees for the condominiums and that any funds dispersed paid off her mortgage, but she didn't pay off those charges. And so the bank now is before the court to ask for a writ of possession. What do you think? She admitted that she received from Kalina $192,000, paying principal and interest of $134 on an original and interest of $34 on an original loan of $61,750. The bulk of the money now claimed by Kalina relates to the payment of maintenance fees on behalf of Marina. So it says, while it is unfortunate that Marina, having paid all the money, Marina still stands to lose all the money. Marina still stands to lose her house, but the law is clear. Where under legal mortgage, being an installment mortgage, the whole money becomes payable by reason of the default of the mortgagor, and the legal mortgagee is entitled to possession of the mortgage property. The court has no jurisdiction to refuse to make an order. Kalina's evidence is that the principal amount became due and owing on the 8th of October, 2008. By several letters, since the parties did the mortgage agreement, and finally, letter dated February 2011, Kalina notified Marina of the amount to Kalina and demanded payment of the sum. It was $60,000. So the court said, in the result, it is the order of this court that unless Marina, within 90 days of the date hereof, or before the 6th of June, 2014, pay to Kalina the sum of $91,000 together with interest, Marina is to deliver to Kalina vacant possession of the mortgage premises. And that's her condo, Brahama. So they gave her March, April, May, June. They gave her March, April, May, 3 months to pay $91,391.20. So she paid up the mortgage, but she didn't pay off the maintenance fees.
The
So if she had-
association was only going to put a lien on a condo anyway, so her better bet should have been to deal with the bank in any event.
Yeah, she should have.
Yeah.
I don't know how she figured she could pay off the mortgage and not pay the maintenance fees.
I mean, you don't pay them fees, as a automatic lien on the place. And they want every piece of it.
Yeah, it's very sad.
But the maintenance fees were, what the bank did, gave her the option that she could have either paid them herself or they would have added it to the mortgage and they made
Exactly.
her aware of that.
That's
So she
exactly
knew
what
that it had been added.
Yeah, but I mean, you know, when you're in a condo, you have to pay maintenance fees. So nobody was harassing her for the maintenance. I'm sure she got notices that the fees were accruing. She knew. And then she got so many letters from Kalina telling her that they were
have to
outstanding.
look out for their interest too.
Mm-hmm.
So they gotta do what's best for them.
And the maintenance fees also sometimes accrue interest upon those maintenance fees as well, do they not?
Yes. Mm-hmm.
So not
I
paying
never
But then-
thought
that.
it was a good idea because you're paying maintenance fees and you're paying a mortgage. That's two.
Yeah.
Yeah, that's two separate payment. And at the end of the day, if you fall short on any one of them, it's a problem.
Yes. Because don't
Yeah.
forget in the mortgage deed itself, you agree to pay them all disbursements.
Yes, you do.
And the association, don't they also have the legal right to put a lien in on the condo after the bank's mortgage is satisfied anyway?
Yes, the bank, because it had mortgage, paid it for her.
Right. But had
Mhm.
they not have paid that, the association could have then gone after for the maintenance fees anyway and taken the house anyhow.
Yes, they would have.
Mhm.
So she would have lost on both ends. She actually lost her whole home. Maybe she should have just gone to the bank and just worked for something to pay off her maintenance fees. But maybe she couldn't keep up both payments. Maybe that's why she ended up in the predicament. she
Yeah. So this thing Kalina said, the Kalina also charged her $550 for appraisal fees. That's to get the fair market value of the property in preparation of the sale. And Kalina said they had administrative service charges, $20 fee charged by Kalina every time they had to debit her account to pay the condominium maintenance fees. They paid it 16 times, so they take 16 times 20. But they said they reduced it to just 8. They also had a return check fee in the amount of $160 that they paid. So she got the letters. She just didn't pay.
Ms. Archer,
Mm-hmm.
like in case scenario like this, is I have seen like cases in this before I work in mortgages at Finco. Mine with maintenance fee, I think some people for me that they just totally ignore it. They would, like you say, they will get the notices from the association. And I know that there was a case scenarios we had recently where even the association, they got lawyers to have the people paying the people and they just refuse to pay the fees. So then in turn, the attorney write letters to the bank, letting the bank know XYZ is outstanding. And at the end of the day, like you said, we secure ours. So what we did as a bank, we applied whatever the amount was, we applied it to the client's mortgage and paid a association.
Yes, right. The same thing that Kalina did.
Yeah,
But you know,
But-
that's already a warning sign, you know. If they cannot pay the maintenance fees, what do you think is going to happen in the end?
Exactly, that is a warning sign.
So right.
Maintenance due every quarter. So that means every quarter you have a problem. That means every quarter the bank have to pay your maintenance fee. That's something.
So
to
that's
think about.
another thing right, when you grant a mortgage for a condominium and you're looking at the client's debt, you have to make sure you include in that maintenance fee.
Yeah,
Because they can qualify for the mortgage. Cannot qualify for the mortgage fee.
yeah, so true, you're so correct.
the credit union we don't do condos because the battle with the condo association isn't even worth their headache.
But also too, fees and associated with those gated communities also, don't have to necessarily be a condo.
Yeah, you all of them, once they're gated, you have to pay fees.
But like you said too earlier, Ms. Arthur, some people might have paid the
Exactly.
mortgage but can't pay the fee. So sometimes it is good to incorporate the fees in say with salary reduction.
Yes.
So at every quarter, you could write a check and just send it for them if they can afford it.
I know what us, in most cases scenario, what we do, like you say, we will include the maintenance fee. I mean, we learned a lesson after a while. So what we would do, we would include the maintenance fee as a part of their payment and just have that in an escrow account. And every
Okay,
quarter,
right.
yeah, we send it to the
Yeah.
association.
Yes.
Yeah. But I wonder why Kalina didn't try to restructure this. Because that's a lot of money for her to find. Almost 100 grand. Did a demand that she should come and pay it. It's obvious she's either using the money for something else or just can't afford it.
Exactly. So where is she supposed to find 100 grand from?
I don't know.
Then she can't even pay her maintenance fees.
Yeah, I don't understand. Yep. So they say when the action commenced in December 2011, the amount being claimed by Kalina was $59,810.15. However, at the date of Ms. Ferguson's supplemental affidavit from Kalina, a little over 2 years later, that amount had increased to $91,391.20, being principal of $73,616.47, interest of $17,624.73, and other fees of $150. What kind of interest rate they charging on this money? Well, it's a lot.
I was looking at this and especially, I don't,
Go to paragraph
boy,
50,
I don't know.
page 12, paragraph 50, page 12. I don't know how these numbers could jump like this.
Maybe
I
she,
really don't know.
maybe she wasn't making full payments and it was partial payments. So most of her payment was going to interest and not principal anyway.
Go to paragraph 46.
But that is really a lot from.
No, go to paragraph 46.
Yeah,
It says, the plaintiff admits having received from the defendant the sum of $192,401.25, being principal of $59,261.77 and interest of no.
Something is
No.
totally wrong with this. That's correct.
Of an original loan of $61,750. What kind of interest is it?
But don't forget now, they kept on having to add the fees that she failed to pay to her mortgage. So that kept on increasing the amount. So whenever she did make payments of any kind, a lot of that was paying up interest and also additional monies that had been, added back to the. People understand exactly what they're getting into, because, signing up on a mortgage is like getting in bed with the devil.
Tomorrow, I'll see if I can find you some more, but I think a lot of these cases will give you some idea of things that you need to consider when you grant mortgages. And it's obvious that when a person comes to borrow money, they really need to understand what those covenants mean. Because if the bank says on their side that they could consider advancing funds to you in order to meet your covenants, and the bank is advised that, okay, your client is behind, and they realize that this is their security, and that fee needs to be paid in order for them to maintain that security and get the value that they're looking for, they're going to pay it, advise you of it, but you don't have the funds. You really have to advise clients when they come for mortgages what that means in those covenants. Your
When the-
mortgage could automatically
When the
increase.
bank pays those fees too, you're now paying interest on that money that they paid on half, as well as it's increased the balance of your mortgage.
Yes. And if you how much she has paid already on that loan, that is outrageous. You see the interest? That interest alone will cost me to run. That is too much money. That is just too much money. But what could she do? There's nothing she could do about it. But she will lose her home. It's sad. All right, so for tomorrow, I know you won't have a chance to read. So I better not ask if you, should I ask if you've read? Yeah, I will. But we'll go through module 4. And again, I'll try to see if I can find you some Bahamian cases. I sent you some English ones. I'll look for some Bahamian ones to go again, see if I can find something for you on some of these topics in terms of the remedies of the bank. All right?
Okay.
Okay.
Okay, all right. So see, I stick to my guns today. I said it is a short class, I'm done. All right. So talk to you all tomorrow. Okay?
Okay, thank you.
Good night.
Good night.
Good night.
Night.